Good morning, viewers. Thank you very much for watching Punchline Africa Television. Today is an exclusive day. It's an exclusive day in the sense that we shall be bringing an exclusive analysis of yesterday's ruling and the judgment by the Kenyan Supreme Court seated in Nairobi on 31st of March, the year 2022, the year of our Lord. Today is a great day that I take on this task. I take on this task on behalf of millions and millions of Kenyans, Africans, East Africans, and the world at large. That for almost 11 years, I have been advocating for a strategy of redemption strategy, a strategy of bringing peace, a strategy of bringing reconciliation, accountability, truth-telling, restitution, and above all, I have been toiling up and down the valleys of this great nation to tell the story of a healed country. I've been trying to put my stand, my experience, to find a united Kenya. A Kenya united, where healing is the answer to the perennial difficulties that come after every election. Today is a great day for me that I will be here to analyze to my viewers and those listening to me, and especially the diplomats who have asked me, over 10 of you, to talk about the idea of BBI. Talk about the idea of a redemption strategy. Talk about the idea of reconciliation, unity of purpose, azimio la umoja. Talk about the idea of a handshake. Talk about it. Several diplomats, thank you. And I will take this stand, and other people. I will take a stand in 3 approaches to 4 approaches. First approach, I want to thank all the people that have helped me in this search for a redemption strategy in Africa. A redemption strategy worked in South Africa. A redemption strategy worked in Zimbabwe between Mugabe and Joshua Gomo and Mugabe and Ian Smith. A redemption strategy worked in Uganda between the LRA, Konyi, and Museveni, rebels and the government. A redemption strategy has worked elsewhere, where people have come together in Colombia and other places in the world. Today is my day to challenge, to open up, to expose, to underpin the difficulties, the challenges, the obstacles, to bring a story of how this matter was bungled, how the judiciary in Kenya bungled the matter, how political interests in Kenya bungled the matter, how a captured judiciary became political and became activists, imported words into a constitutional matter that would help this nation. Today is my day to tell the story, how painful it is to defeat an enemy and then you come back to face the same enemy. How powerful it is to be the only person left in the arena to safeguard the interest of the people of Kenya. From 2009, 2007, 8, 9, 10, 11, the only souls that was left, and the soul that was left in this country that fought about the nation called Kenya, that fought against the forces, the darker forces that had wanted to dismember this nation, was my soul, my mouth, my heart, my body. In 2015, when the ICC cases, one was temporarily halted because the evidence was there, but evidence was tampered with. The other one did not have evidence at all. I started on a case of a redemption strategy, a route of redemption. How Kenya can heal, how Kenya can come together, how Kenya can work, how we can restitute, how we can redempt, how can we reparate the internally displaced persons whose homes they have been taken and who have not gone back to their homes as we speak today. I did not know that the two leaders, Raila Amolo Odinga, President Uhuru Muigai Kenyatta, were also thinking in the same breath. President Uhuru Kenyatta was thinking of leaving a nation that has a perennial history of every 5 years. That nation has violence. Every election year, before, during, and after, someone has to die because of elections. Someone has to die because the votes were killed, were taken, were done what? This is the nation, and we have to face it. It's only on 2 occasions, 2000, 2013, that I have been very much involved. But from time memorial, refugees that I left back in Kenya in 1985 came running to the United Kingdom in 1992 because of bad elections. They found me there already. I helped them to resettle. If there are those who said they were not helped, then let God help us. In 1992, the violence was orchestrated by very many factors. One of the factors came from an election, a badly managed election. A badly managed election that we must find, that we must sit and analyze why elections always cause trouble in Kenya. The Kenyan election, therefore, and the Kenyan elections have been the trigger for a very happy country, peaceful country, exploding every 5 years. Ladies and gentlemen, those watching this lecture, public exclusive lecture, let me come to the subject of yesterday. I have respect for the judges. I have respect for the judiciary of Kenya. I have respect for the Constitution of Republic of Kenya. But I don't have respect for activist judges. Let me repeat that. I have respect for the judiciary of Republic of Kenya. I respect the judges, some of the judges of the Republic of Kenya. But I don't respect activist judges and the judges who make rulings through fraudulent means, who act fraudulently, who act like activists, who create fourth pathways. A fourth pathway was created in the courts. There is a fourth pathway in the courts, contrary to the doctrine of Montesquieu. Montesquieu had a doctrine of three-layer states, patterns. One, the judiciary. Two, the parliament. Three, the executive. Where is sorry? Where is the doctrine of separation of powers? The doctrine of separation of powers does not lie in creating a fourth pathway. A fourth pathway has been created in Kenya, in the Kenyan judiciary. If people don't want to speak, I'll speak and go home. I've no regrets. I've no regrets. Those who want to listen will thank me later. And if we don't speak today, when are we waiting to speak then? It's a tragedy. A tragedy of Africa. It's a tragedy in Africa that we, as Africans, behave in a dangerous manner. We, as Africans, behave very badly when we are supposed to behave in an organized manner that can bring Africa up to the standards of being known as an African country. Our continent, therefore, suffers from people who don't speak the truth. Our continent, therefore, suffers from people, individuals, who keep quiet when things are going wrong. I'm not one of those in Africa who keeps quiet. I'm not one of those in Africa who would like to keep quiet and watch things go wrong, then come up in the morning to blame others. Today in Africa, lots of things are happening. But one of the things that has made me to come up with the podium politics, that at least every Friday one has to do a podium politics to enable people to understand, to lecture the truth about Africa, what kills it, is this. Yesterday, the Supreme Court of Kenya decided on 7 factors. They decided on whether BBI was conducted in a manner, whether there is a basic doctrine, and that basic doctrine, whether it applies in Kenya. The 7 core pillars of the BBI as taken out from the appellate court to the Supreme Court presented 7 factors that are part and parcel of the 9 points that President Uhuru Muigai Kenyatta and Raila Amolo Odinga decided and wanted a better Kenya to come out of the 9 points. Ladies and gentlemen across the world and the diplomats who asked me to speak my mind, thank you. I can see some of you are sending me messages. Yes, I'm going to speak my mind today. That if I don't speak, don't tell me I did not say it. On 21st of May, first, before I go there, the Kenyan court, in a majority decision of 5-2, they decided and agreed that the BBI was unconstitutionally introduced to the public of Kenya. I am not going to go into the details of disagreeing with them, but I'm going to disagree with them. Who are we? What is it? We, the sovereignty of the Republic of Kenya, we, the people of Kenya. What does the Constitution say? We, the people of Kenya. The Constitution of Kenya does not say we exclude Uhuru Kenyatta. He is not a Kenyan. I want to tell the world that I am going ahead, and I want to tell you quickly so that you know what I am going to do. I'm sorry, but I want the East African Court of Justice and Human Rights in Arusha too. I am not seeking people to pay me. I'm not seeking to undermine anybody. But I want an opinion for the world. Because when I talk like this, some brokers, there's a lot of brokerage. We run with this, and then you fail in the end. Some brokers will run and say, let's go. You don't go where you don't know. If you're a grave digger, remain grave digging. And if you're an architect, remain building the buildings. Don't turn yourself into a job you can't manage. I oppose the ruling of the 5 judges on the question of 1, Uhuru Kenyatta participation as an individual. I oppose, and I would like, as a member of the Commonwealth, to seek a situation, to seek an opinion from other courts that are not Kenyan courts. That's the announcement I'm making tonight, this morning. Whatever you want, know it. I'm going to do it. I'm not asking you for money. I'll do it. My papers are being filed, and I'm waiting for justice. 2 judges, my Justice Njoki Ndungu. I want to ask you to give me that judgment quickly. Bring it out on, I want it in wholesome. I want to show people, I want to leave a legacy in this country, in this East Africa, that I did challenge the ruling of the Supreme Court of Republic of Kenya on Kenyatta's participation. Kenyatta being a Kenyan, we, the Constitution of Republic of Kenya, not we, the people excluding Uhuru or excluding President who or excluding Kibaki. We, the people of Kenya. I want to go from there. I don't want to tell you my tactics. I will not need lawyers. I will only need lawyers to prepare me and to prepare my documents. I've instructed my international lawyer, Chief Charles Taku, and others to prepare those documents. I want to wrestle with these guys across there. They went to the same schools that I went to. It is not because I want to gain anything, but I want to leave a mark that you don't lie, to leave a mark that don't just copy and paste documents from your researchers without reasoning. So when the document says we, the preamble of the Constitution of Republic of Kenya says we, the people of Kenya. Allah, then exclude Kenyatta, is not a Kenyan. Then you tell the IEBC, which is under Kenyatta, to conduct an election, to conduct signature collection. Then you tell we, the secretaries, the people in charge of security, we, the people of Kenya, we. I found it laughable. I was telling my friend of mine, when they were doing elections, and I don't want to say it here, of this Chief Justice, I told them, I warned, and luckily enough, I'm a very humble man. And my God, Jesus Christ, thank you for loving me. You always tell me the truth. And when I say the truth, some brokers just start laughing. Now it has come to rain. It has come to prove that I was right. NGO syndrome, civil society syndrome, civil activism has entered this court. They have created a fourth pathway. A fourth pathway. Mark my word. Pathway number 9. That they would like to safeguard the Constitution and make rules from the court, not from the parliament. Ladies and gentlemen, what has pained me most is one man called Dr. or Professor Duncan Ojwang. A great friend of mine, Duncan Ojwang, but a very bad traitor. A great friend in intellectual matters, but a very bad man in betraying the cause and the intellectualism. I and Duncan Ojwang are great friends. We go back in the ICC. We go back to Bashir case in Khartoum, where both of us gave papers, and my paper was resoundingly backed by a standing ovation from President Bashir, with the entire audience on feet for 5 minutes, clapping for my speech, because my speech touched Africa on the question of ICC. I have been keeping quiet, but I think I better speak now. Duncan Ojwang called me and told me he's the one who wrote the judgments in appeal court. Yes, I recorded our talk. I'm not like a Sonko, but my phone operates itself. He told me that he wrote the judgments in appeal court, and Matanga, you will not manage me. I said, just Duncan, Professor Duncan, is this what you teach your students in Nazareth University? There is nothing like a basic structure in the world. There is no constitution in the world, and let's not be lied by Justice Mohammed. My brother, my friend, I like, that's a lie. There is no basic structure in any constitution, in the world. All structures in the constitution, all articles in the Constitution are the same. There is no structure. There is no constitution which is supreme. There is no constitution that will not take you to jail. Hello, lawyers in Kenya. If this is what you studied at LDC, I don't know, Kenya Law School by Professor P.L.O. Lumumba, I want to challenge him. Let him show me one article that does not take a person to jail if you are taken through the penal code. From that article, all articles that are here, if you don't work on them, somehow you will end up in committee. All the articles in the Constitution of Republic of Kenya can easily take any citizen to court. Violate one of them. I can give an example of NEMA. If you build a house in the middle of the road, there is a full article on environment in the Constitution made in the penal code. You end up in jail. Because some people think I talk with no brains here. Go and build a house without doors. The council will come to ask, why are you building a house without doors? There's an article in the Constitution that protects people who build houses and tell them how to build the houses. So Professor Juang, we had a very terrible quarrel. And I'm telling you here, frankly, I told you, I promised you I will talk about you. If you have anything to say, you can say it directly to me. But you're a traitor. You are paid money by Ruto to dismember this court and create a fourth pathway. If that is what you teach your students in Nazareth University, then it's a sorry state. I saw you yapping on K24 this morning about Kenyatta, about President Kenyatta resigning with the Attorney General of Republic of Kenya, but you don't want to resign when you evidence, which I have, is brought to the public that you actually wrote, and you told me you wrote the basic doctrine, and I told you I write the best doctrine and defeat you. Then you resign first before Kenyatta resigns. Ladies and gentlemen, there is no constitution in the world that has basic structures and amendable articles. It's impossible. All articles in the Constitution are amendable. That I agree with the judges, those who said they are amendable. I also go further to disagree with Justice Mwiru. She has never been my favorite judge anyway, but I disagree with her on the question that there is a basic doctrine in the Constitution. No. All articles are the same. You can break them. You can change your Bill of Rights today. Kenyans can change their Bill of Rights. They can say, we don't want bail applications given to thieves who steal money on Friday and get bail on Monday and go home, eat the money in Seychelles or Dubai with their relatives, wives and girlfriends and calicos. You can change it. So there is no article that is not amendable. That one, kudos to the judges who said so. Coming to the two, Ojwang tells people how he is well positioned with his knowledge, bure kabisa, that he is. There is a doctrine or basic structure where you don't touch structures of a constitution. No. The judges went further that Kenyatta is not a Kenyan. Kenyatta is an abnormal Kenyan, is it? That's what they if I can interpret it to a layman language. You people listening to me across and who will take this step. I want it, all of it recorded without one word taken out. That Kenyatta is not a Kenyan. Therefore, Kenyatta cannot talk about Kenya because he sits in the house as a president. And as a president, if he sees the country going to war, people are cutting each other with pangas, he can't order to find the root cause why pangas come every election time. I wanted an opinion of other judges who are maybe more superior than the Kenyan Supreme Court to interpret for me independently whether Mr. Kenyatta's right, whether President Kenyatta's right has not been infringed. Because it will happen to any president. Ruto can shout and open his mouth and say we want them to, but he is going, if he wins an election tomorrow, Ruto, which I believe is not, if he has to win an election tomorrow, Ruto will suffer the same consequence. So when you laugh and open up your mouth and say, we want them to say they took this, they were cleaning the country so that you can lead it properly. What has annoyed me most and what has angered me most is the idea, therefore, of stopping a healing process. On 21st of May 2021, I sat down after the 5 judges of the High Court had, the 5 of them made a ruling about the BBI. I brought up a document which you can find, and I will direct my researchers to take this document to panafricanforum.com, transfer it there, so that the people across Africa can read. And I want to tell the courts that when you send your researchers to go and research for material, please let them also, you people who are reading the documents to the public, also acknowledge the sources of our documents. Some of you read my documents, use my work, steal my work, and then earn a living out of my work. I'm not going to accept this time. God has told me to say it. I created a punchline here. Certain people stole my punchline. I kept quiet. Now, a lot of my work by a few of researchers has been stolen. And it found itself on the table last night. It is all here, pages and pages. And this paper is very important. I wrote it on 22nd, on 21st of May, and it was published on a Kenyan website of capitalfm.co.ke. It's not Matanga. It was published. Fortunately, all the people ran to this document, in where I stated the fact number 1, that the president can be sued, the declaration that the president can be sued in personal capacity in civil proceedings is not correct. I'm summarizing it for you. It had malice and a motive from the bench. Article 143, this is my analysis. not the analysis of those who copied and read without acknowledging. Civil proceedings shall not be instituted in any court against the president or any person performing the functions during the office. So how did the judges arrive at suing the president in his individual capacity? I reasoned. In my considered view, this declaration cannot stand the test of sober judicial scrutiny in an unbiased court. It looks like the court stretched its powers to the extent of actually amending Article 143 to actually not amending, but the High Court actually expunged. That's good English of Shakespeare, which I have. Cannot be separated. The above findings, therefore, cannot be separated. That the President Uhuru Kenyatta is, and they said, was in breach of Chapter 6 of the Constitution. They went further to recommend, without giving Kenyatta a natural rule of justice, condemned him and heard. How could a court arrive to such a decision? Ladies and gentlemen, it is a very serious matter here. Article 143.2, again, is very important. That's fact number 2. An in-depth analysis reading of what they wrote, that the president can be sued, tells you that the judges were calling for President Kenyatta's ouster. In fact, the judges wanted Kenyatta ousted through judicial coup. The judges performed the coup of the High Court. I don't know why the Chief Justice and the Supreme Court did not reprimand these judges. That's why I've come up to remind that in the future, the behavior of Mr. Harvey and Grand Mula should not just be a condemnation by words. These people do a lot of harm after getting money from Ruto. They harass us on social media. They malice us. They insult us, especially Grand Mula, claiming to be with one small degree and telling people who have degrees, who have read more degrees because he has stolen money from pirates. You know, these are some of the things that I don't agree with some people. Fact number 3, I have to fight for my rights. And I have a right as an individual because I wrote this. It's my writing in my night, my burning the oil. That the requirements of amending what the court referred to as rather declared an eternity clause. This is on the basic structure. I disagreed with the judges then. The basic structure doctrine has been used, and they said Malaysia, Pakistan, whatever, but it was used. But has it got a root in any constitution? Go to Malaysia. Go back to Pakistan. If you steal money in Pakistan or Malaysia, if you go with drugs in Malaysia, they send you for life imprisonment. In Malaysia, Kuala Lumpur, they have changed the constitution. There will be no basic human rights, no basic structure there that protects a human right. Anything to do with cocaine, a drug, cannabis in Malaysia, you go down. I wrote on that day. I quoted Article 256. I quoted Article 255. Judicial deep sea fishing aside. They went for a deep sea fishing, not an expedition. But the deep sea looking for the sharks and the seals that are under the sea. The supremacy of the Constitution in the territory of Kenya, sovereignty of people, we the people, the national values and the principles of governance, mentioned in Article 10A, 10.2A to D, the Bill of Rights, the term of office of the President, the independence of judiciary and commissions and independent office, to which Chapter 15 applies, the functions of Parliament, the objects, principles, and the structure of developed government. All provisions of Chapter 16 are all available for people to read. You can do that. How the judges fished. They created a fourth pathway. I'm trying to remind the Chief Justice here. I respect you, madam. But a mere condemnation of your lower court, who are trying to create a fourth pathway to create chaos in Kenya, is not good enough for Matsanga and for other Kenyans. I'm not a Kenyan, but as an international scholar anywhere in the Commonwealth, where I see a problem, I speak my mind. Therefore, how judges reached this, I don't know. How the High Court reached this type of life is up to the Chief Justice to tell the world. She never reprimanded them. Because the apex court is supposed to give a recommendation and say to them that never again should such politically motivated judgments come into a good court in Kenya. Ladies and gentlemen, you can get that article, Fact 4, the declaration of IEBC, I wrote about it. Fact 5, the principle of public participation required by Article 10, 118, 124, 201, 221, and 222 were fully met. The biggest problem with the Kenyan Constitution is you have not told us how much participation, how many people you should participate in. The period of participation, 10 weeks, 20 days, 1 day, half a minute. What is participation? You need to specify. So the MPs in Kenya should go back to Parliament and specify that it must be 2 weeks, 1 week, so that if people don't come, we shall not come back to you. But it's vague. The doctrine of colored legislation, colored, which I can call the colored legislation, is based on a maxim that what cannot be done directly cannot be done indirectly. As regards parliamentary legislative competence, the doctrine is such that Parliament cannot make laws or make amendments fraudulently outside the purview. The Parliament cannot do indirectly what it cannot do directly. A law is regarded as colored when in Parliament, having no powers to pass such a law, frames the same Parliament, camouflaging the same as if it falls within the competence. We want to find ourselves in another court somewhere outside Kenya. It is important to understand Parliament has unaffected powers of competence, unaffected competence to pass the amendments which do not fall under Article 255(2). In passing a law or amendment which Parliament has competence to pass, the motive which makes Parliament pass the law is irrelevant. That must be known. All in all, I come back to, as I finish, there is quite a lot of gray ground or gray grounds where an outside independent court can give an opinion for future reference. Because the Supreme Court in Kenya is the final court. But the East African Court and the African Court of Justice are the most important courts on the continent of Africa that can be used in making sure that justice and all African countries and the justice systems operate within the purview of the law. It is therefore very important, my fellow Africans and East African and diplomats watching, that Kenya has missed a chance to heal. Kenya has missed a chance to have a redemption strategy. Ruto finds it very important when he sees people in Timboroa sleeping in other people's houses. When he sees smoke, people cooking in other people's houses in Timboroa and other parts. When the others, the owners, are sleeping on the streets of Nairobi, their children are eating nothing in Nairobi. Their farms have been taken over. Nobody has reparated them. Ruto finds it very politically interesting to say that the president should return the money and find out how much money was used because of the hatred of Raila Amolo Odinga. Yet he took over a farm. The man went down to God without eating even a mango from his farm after he had taken over. This is the man that you people in Kenya, this is the man who went to pay for the Ojwangs and other people and that some other people to mutilate the BBI, the redemption strategy that I had struggled for. This is the man who is coming back to tell people that he wants President Uhuru Kenyatta to account and apologize. This is the man who has occupied people's farms, who has a record of occupying a farm and making sure he eliminated almost Mr. Muteshi. This is a man who has got a record that we should not keep quiet and we should not be silenced because he has threats and he threatens people. When you frighten people, be careful. Leave some space for you also because you could be threatened. This is a man who has no shame, who stands here. This members, his friend's police, goes to his friend's home, tells his friend's neighbors that Uhuru Kenyatta is useless. He has done it. He has done it. He has done it indeed. He has annoyed some of us who are friends of Uhuru Kenyatta. Uhuru Kenyatta does not pay me to talk. But I'm a friend. Let him hear this voice. That enough is enough. You have done very well. You wanted a united Kenya, but people don't want it. The judges that we thought are worth, some of them connived with civil societies. They have a syndrome of civil society mechanism, syndrome that falls in their blood, that they will never forget activism. Mr. President, some of us stand by you. We have no regrets for standing by you. You have a legacy. You have a better East Africa. You will have a better East Africa. You are Pan-African. But what you wanted is to get a better Kenya so that you can move in the legacy. Leave a legacy that will come out shining. The judgment yesterday on basic structure, we agree. On eliminating the president, I don't agree. Therefore, I have my grounds. I will accept what the court has said, but I disagree. I will take Justice Isaac Leonola and Justice Joki Ndungu rulings. I'm waiting to read for them. Please, the true judges, tell your PAs to send a copies, because they might be not available. Send me real hard copies. You have done very well for me. You have done very well. Send me copies. I'll make history. There's something that is not right. You can't say Uhuru Kenyatta is we the Kenyans, and then he is not a Kenyan. He votes. He takes part in voting. He takes part in sharing the CDF. He uses the road that CDF constructs. Hala, then you say he's not a Kenyan. He should not take part in directing how a Kenyan can propose how we can go. I want to leave a question to ask the judges. How will Wanjiku, Nafula, Sophia from Garissa, Nekesa, ordinary Nekesa, ordinary Otieno, with no shilling in the pocket, how will she or he collect 1 million signatures? I want to ask the judges yesterday. How? If you can answer that to Kenyans, does he go to the bank and break and steal to collect 1 million signatures? Will he use saliva? Will he use water? How? You should have recommended a way. I saw my land good friend Professor Wanjala using so many words, volcanic, tsunamic. Professor, but you did not recommend it to us how the Wanjiku can organize the 1 million signatures. I challenge you academically. Let's talk. You are my friend and I'm going to look for you. We talk. You destroy me on an argument. Prof, I'm waiting. There are friends of mine there. I want to discuss. Tell me how Wanjiku, how Atieno, Nekesa, Sophie, Otiende will collect 1 million signatures in Kenya without the help of someone. The judgment of the Supreme Court are welcome, but they leave a lot to be desired. Thank you very much, viewers. If there are any questions, anybody can ask from the panel. Those who are watching, otherwise, that's the end of the exclusive show this morning. I've ended it that way. I will pursue the matter for opinion cases. I want an opinion. It's not vindication. It won't erase what, but I want it to go in the history of Africa that I challenged this opinion that the president of a country cannot take part in the same thing that helps the same president and others of the nation. I submit.